It's an annex to whose affidavit?
I just want to be clear.
Is that in the Mbonisi?
This is an affidavit.
Oh, okay. And what's the date of the affidavit?
This unsigned one
Yeah.
is what we asked to be admitted in terms of section 3.
Yeah.
I just want to see where it deals with it.
In any case, that is a letter.
That's not in the letter itself can't be a dispute
Yeah.
because it was written.
Yeah. Air conditioning working here. This fire.
It was cloudy, that's why it was like paragraph 132. What you're now going to is the annexial 19. But in paragraph 132, you find that on page 107. Yeah, he deals with that letter. There he puts the whole issue right up to the top.
Okay.
That will be the good.
Okay.
Stating her preference.
Yes.
Morani, before you start,
Before I start,
may I just one or two things which I need to say before you start.
Yes.
To the members of the media, of course you've been granted permission to record the proceedings, but in that permission each of you also undertook to adhere to the normal and customary rules and restraints on media coverage. And one of those which I need to insist on, repeat again, and will be enforced is once proceedings have concluded or when the court adjourns, then when the practitioners talk amongst themselves or with their clients, that of course is privileged and not for media scrutiny, and I direct that you refrain from interfering with those rights in any manner or fashion, by way of notes or recording or otherwise. I trust I've made myself clear in that regard. Then a second point is, as we went on during the course of yesterday and as we concluded with everyone restraining themselves and conducting themselves as one should in a court, I trust we will continue in that fashion this morning. Then the last thing, Mr. Morani, before you start, if I might impose on your time, I just have one or two questions for Mr. Dodson regarding his argument of yesterday.
as my Lord pleases, in any event, he had requested that he say a few things, hand up a document before I start.
Oh, he wants to continue. And this after I said yesterday that his timing was so impeccable.
My Lord, may I interpose just on an issue which flows from what your Lordship said? Whilst I'm normally not averse to being in the limelight, I must say this light is extremely disturbing.
Well, members of the media, of course, that's part of the rules, that when you do the coverage, that it doesn't interfere otherwise with the process. Thank you.
Thank you.
Mr. Dodson.
As the court pleases. Lord, may I beg leave to hand up, we indicated we prepared a draft order.
Yes.
If I may beg leave to hand up the draft order.
You have, of course, also uploaded the draft order.
Indeed.
Otherwise, I just accumulate.
Accumulate paper. Lord, I'm very happy to take it back.
All right. Where shall I find it on the case file?
It's 72.
72.
Perhaps I could just take your Lordship through it to indicate where its roots lie in the amended notice of motion.
It might also address the question which I wanted to ask.
If I may inquire whether your Lordship has it on case file.
Yes.
It's
72-1. It's in two versions, PDF and Word. Yes, I have it.
Lord, just to give your Lordship the roots, paragraph 1 has its origins in paragraph 4
of the notice of motion. Yes.
Paragraph 2 in paragraph 5 of the amended notice of motion. Paragraph 3 has its roots in paragraph 6 of the amended notice of motion. And then paragraph 4 is our main relief that has its origins in paragraph 10.1
Yes.
of the amended notice of motion. Then, your Lordship will see from the last page that we are not persisting in the setting aside relief that was foreshadowed in our notice of intention to amend, or our notice that we bring an amendment application. So the one that sets aside everything that the King has done in the interim, we are not proceeding with that relief. So that notice of amendment falls away unless your Lordship is against us. And
That's the 6 bis paragraph. That's the 6 bis paragraph
Indeed.
that was sought to be introduced.
Indeed.
All right. While we're on this topic, because this also, the draft order also addresses the question which I thought of in an insomniac moment last night. As you know, Mr. Dodson, judges never sleep. So last night, if your primary relief is, which you now almost said is primary relief, that's the section 8.4 steps, and that's the investigative committee. So if the argument is that the President, in view of what you say was a clear dispute or allegations of a dispute, should have or was obliged to take the steps in terms of section 8.4 of the Act, to have whatever was presented to him as a decision investigated. So if that decision is to be investigated, is it then still appropriate or even competent to grant prayer 1, which was your previous prayer 4? That is to set aside the exact decision which you want him to investigate.
Well, what he investigates is not so much the decision as to whether the identification was in accordance with the customary law. Now, I realise
Yes,
that,
no,
that's a difficult submission to make, but the scenario I want to postulate is one where everything goes according to plan in the identification process, but the only step that's flawed is a purely legal error.
But even if that's a legal error, isn't it premature then to have a court set that then aside? Because the process leading up to that is what he's going to investigate. That's what the dispute was about.
If I may be given the opportunity perhaps to reflect on it and come to a final position,
all right.
But it does seem to me...
Because in logic it seems to be inappropriate. There's the identification decision. However or whatever, or legal or royal family, or the requirements, etc., there's a dispute about how that came about, whether that was in accordance with the prescripts of the Zulu nation. Then it comes to the President, and there's the dispute. Now, you say he was obliged to go to 8.4, and he shouldn't have made a recognition decision. So the recognition decision is what you want to set aside. That's fine, and you want him to revert to this position. But on this position, how can one then set aside the jurisdictional fact leading up to that position?
My preliminary response, if we may be given the
jurisdictional hurdle, jurisdictional triggering.
My preliminary response would be that it probably doesn't matter. As long as there isn't an inference drawn from our failure to challenge the identification decision that we accept that it was correct, which wouldn't be the case, but perhaps for purposes of, if it was looked at a later stage, one would need to somehow record the stance of Prince Simakade, which is that that process isn't accepted as having led to a valid identification.
So that was my first question, and it pertains to the draft which you've now handed to me and uploaded. And the second question was just on a matter of argument. Yesterday, near the conclusion of your argument in dealing with the res judicata issue, you referred me to cases which indicate that an order granted for an interim interdict or interim relief is, of course, because of the nature thereof and because it is subject to amendment by a court, it is then, in that sense, not final and should not be deemed to be res judicata. But that's when there was an order granted. In this instance, the finding was to refuse that order and to make findings on the reasons for that refusal. It's on a slightly different footing, is it not?
But with respect, it's in exactly the same proceeding, so it must have the same status either way. It can surely not be that if the interim relief is granted, then those decisions have no standing. But if the interim relief is refused, then they suddenly do have standing. We would submit.
You say it's the same, all right. But it is notionally different because if an order is granted, then it's subject to amendment or could be subject to amendment. If no order is granted, there's nothing which can be amended.
Well, except that it might, for example, have simply been on the basis of urgency ultimately or something.
No, but I understand you say it's still the nature of the proceedings as interim interdict proceedings.
Indeed.
And therefore whatever is said either way you say should not be binding as res judicata.
Indeed.
Apart from the other arguments of parties, etc.
And my Lord, in a way, it makes it worse, not better, for the second respondent, because if one looks at the order, there is absolutely nothing there to suggest that a decision was granted somehow favouring the second respondent. There's no declarator to be found in there, some sort of an interim declarator, or some sort of a prima facie finding in his favour. And that's why we also say that if Prince Simakade had been unhappy with that, there was nothing that he could do. He couldn't appeal that dismissal.
Yes,
So he would be completely stymied. He'd be left without a remedy. It would be inappropriate for him to intervene as an applicant in those proceedings because they were doomed to fail. It was brought on the basis of a rumour. No level-headed person would intervene to support the applicant in those circumstances. And if...
All right, no, I understand that. It was just that interim portion on the order granted, it seems that those cases are to be distinguished on that basis. But otherwise, I get the point.
May I make one last thing that I'd like to record in relation to the draft order? What we invite the first, second, and third respondents to consider and to convey to the court is whether, in the event that the court is ultimately against them and in favour of reviewing and setting aside either or both of these decisions, in those circumstances, we invite them to indicate whether they would go along with the relief that we are proposing be ordered in this matter, pursuant to the reviews.
Right, but that I suppose you could have addressed to them as well.
Indeed.
But now you've mentioned an open court. All right, thank you.
Mr. Court.
Mr. Morano.
As my Lord pleases. My Lord, I associate myself with the opening remarks of my learned friend for Prince Mbonisi about...
Advocate Masuku.
Advocate Masuku, that's
yes.
Right. About the gravity of this matter and its importance, particularly to some of us who come from the kingdom of KwaZulu-Natal. What has to be appreciated is that whatever decision the court makes will affect the lives of millions and millions of people in that province.
You can rest assured I'm under no illusion of the gravity of the matter.
That's good.
If I had been, then apart from the submissions made, the attendance at court also underlines that.
Absolutely, my Lord. Yes. Yes. Well, my Lord, in making submissions on behalf of the President and the Minister of Cocta in both matters, will make the following submissions. Firstly, I'll provide an overview of the main opposing arguments of the President and the Minister. Secondly, I'll deal with the status of Madondo AJP's High Court judgments and order, and also the status of Prince Mangosuthu Buthelezi. And thirdly, I'll deal with the President and the Minister's defense of res judicata or issue stoppel and show how it is dispositive of the matter. And fourthly, I will deal with the merits of the applicant's grounds of review. And finally, I will deal with the appropriate remedy that this court ought to grant. There are obviously, Lord, certain submissions that pertain only to Prince Simakade, and will identify those during my address. Now, the President and the Minister oppose the applications for the following main reasons. Firstly, we submit that there was a valid identification of the king-elect, King Misuzulu, and a valid application in terms of Section 8(1)(a), Roman 1 and Roman 2, by the royal family before the president. And when I refer to these sections, my Lord, I'm referring to the Act, the Khoisan Act.
Yes, yes.
Yes. Secondly, we submit that there was no dispute lodged before the President in terms of Section 8, subsection 4 of the Acts. And there we underline in terms of that particular section. And thirdly, at the suspension of the late Isilo's will by Madondo AJP in respect of the applicant princess's matter, we submit has no bearing on the identification of the king-elect. And fourthly, that there was no obligation on the President to cause an investigation in terms of Sections 8 sub 4 and sub 5 of the Act. We'll begin by dealing with the status of Justice Madondo's judgment and the implication it raises for the applicants. This is because, my Lord, should the court agree with our interpretation of that judgment, then the matter would be disposed of. Now, the applicants in their submissions contend that the President's recognition of King Misuzulu as king-elect was primarily based on three considerations. Firstly, the findings and order of Justice Madondo. Secondly, the representations made to the President by Prince Buthelezi. And thirdly, not through the identification by the royal family. Now, in respect of the judgment, the applicants also contend that it has no effect as it is subject to appeals in the Supreme Court of Appeal. We submit, Lord, that submission to a large extent is no longer valid, particularly if one has regard to annexures KM3, KM4, and KM5 to King Misuzulu's answering affidavit, to the effect that the princess's application for leave to appeal before the Supreme Court of Appeal under case 2571 of 2021 has since lapsed and also was withdrawn by consent. Now, King Misuzulu's answering affidavit also shows that Prince Mbonisi's application for leave to appeal under case number 10879 of 2021 P was dismissed by the Supreme Court of Appeal on the 5th of October 2022. And this appears, my Lord, on case lines 028, 121 to 162, 028, 135, 028, 137 to 139, and 030 8 to 9, and 030 222 to 223. The only matter that remains before the Supreme Court of Appeal is the application to reinstate the lapsed appeal of Queen Sibongile and the appeal. Those are the only matters we submit that remain before the Supreme Court of Appeal. But now, just to digress a bit, Lord, that appeal deals with essentially two matters. The one matter is the judgment of Justice Madondo with regard to the claim by Queen Sibongile to half of the estate of the late Misizulu. Yes. And also the terms of the will. And we submit that there's nothing to do with this case. And secondly, it also deals with an application for the recusal of Justice Madondo. That matter, Lord, we submit.
You say that recusal is in any event linked to herself because...
Absolutely.
Yes, it's got nothing to do with the identification decision.
Absolutely.
Whether he married her or not has got nothing to do with his decision on the other matter.
Absolutely,
yes.
Absolutely. So
not married, they presided over the marriage.
Yes, of marriage of one of the queens.
Of one of the queens, yes.
That is so. Yes. we submit that wouldn't oust a submission or a claim of res judicata and the finality of the judgment and orders of Justice Madondo with regard to the issues that are before your Lordship.
Yes, because res judicata is linked to a cause of action, so this is a separate cause of action.
Absolutely, and facts and law relating to specific issues. Yes. Now, to continue with my submission, the President agrees that he was guided by the judgment of Justice Madondo, where it was expressly found that the royal family had in fact identified Prince Misuzulu as the successful king-elect. We submit that there was no appeal against Justice Madondo's judgments and findings on this particular point in the SCA. And we submit that it remains valid. Now, it's common cause that the judgment of Justice Madondo was handed down on the 2nd of March 2022, and that the impugned decision by the President was taken on the 16th of March 2022. It's also common cause that the applicant in the Prince Mbonisi matter under case 10879, served and filed a notice of application for leave to appeal in terms of Section 17 of the Superior Courts Act on the 17th of March. In other words, a day after the decision had been made, and that the applicant Queen only signed and filed her notice of application for leave to appeal under case 2571 of 2021P, that's the case number in the Pietermaritzburg High Court, on the 18th of March 2022. The references to these laws, I don't think it's necessary, but just for completeness sake, the first one is 001 191 to 202, and the Queen's is 001 187. So we submit, my Lord, that at the time that the President took his decision on the 16th of March, Justice Madondo's order was in full effect and force. And we submit, and we shall continue to submit, that the President was entitled, if not obliged, to rely on the findings made therein. In the judgment of 8th Secondary School Governing Body, such the Western Cape High Court refused to review administrative decision, having in our submission correctly held that, and I quote, there can be no dispute that Section 18(1), that is of the Superior Courts Act, had the effect of suspending the execution and implementation of the administrative decision when applicants lodge an application for leave to appeal the order of the court, a court dismissing the application, and we refer to...
Yes, you mean the decision still stands, irrespective of litigation, which refused the review thereof, the decision still stands.
Absolutely.
And if you file a leave to appeal against the refusal of the review, it doesn't impact on the decision itself.
Not at all. Not at all, my Lord. Yes. Now, now we submit, therefore, that both prayers by the applicant princesses and Prince Mbonisi interdicting the President from issuing a certificate of recognition to King Misuzulu, they were dismissed, and the applicant princess's prayer directing the President to refer the matter concerning the identification of the successor to the throne as King of the Zulu Kingdom back to the royal family for reconsideration and resolution in terms of Section 9, subsection 3 of the repealed Traditional Leadership and Governance Framework Act 41 of 2003 was also dismissed. We submit that although the applicant's application for leave was lodged on 17th March, may have had the effect of suspending the order and the judgment until its final determination in relation to the order relief sought. The de facto position was that Justice Madondo had in fact dismiss the interlocutory and directive relief against the president. In regard to the decision, the court's decision in the Koti case, we submit that it finds application. There the court held that an application for leave to appeal cannot restore what never was, nor somehow confer a benefit on the applicants that did not exist. Well, transmuted to the facts of this case, the notice of motion of both applicant princes and Prince Mbonisi did not contain a prayer seeking the suspension of the certificate of recognition pending the finalization of their application for leave. Therefore, it cannot be that the late filing of the application for leave to appeal against the orders of Justice Madondo can somehow miraculously breathe life.
You mean if they wanted that, there should have been a Section 18.3 separate application
Absolutely.
for implementation
Yes.
in the interim pending appeal?
Precisely, my lord. Precisely, my lord. Yes. And we submit finally on this position that the correct approach is that found in the SCA case of Snow Delta, we refer to it in our heads, where it found that, and I quote, an order for the dismissal of a claim or application is not suspended pending an appeal simply because there's nothing that can operate or upon which execution can be levied. Yes. Well, in respect of representations of Prince Mangosuthu Buthelezi, the applicants contend that they are not those of the royal family as defined in the Act, and therefore the President was not entitled to rely upon them. But Justice Madondo, relying on evidence that was before him, in particular, Lord, the affidavits of Prince Buthelezi, found that Prince Buthelezi was the only person authorized to convene meetings of the royal family, qua Prime Minister of the Zulu nation, and that no other person had ever convened such a meeting in the past. Therefore, given that the judgment and order of Justice Madondo was in full force and effect when the President took the impugned decision, it must follow, we submit, that the President was entitled to rely on the representations made by Prince Mangosuthu Buthelezi when the President issued the certificate of recognition on the 16th of March, 2022. Therefore, we submit that the President's reliance on the judgment and the representations in taking the impugned decision to issue the certificate of recognition to Prince Misuzulu was valid. That's our submission. Well, in any event, we submit that in the light of the fact that Prince Mbonisi's applications for leave to appeal were dismissed, and the appeals of the princesses were lapsed and were withdrawn by consent, we submit that the point has no substance. Now, I go on to deal with the legal implications of the finality of Justice Madondo's judgment. As I've already submitted, my Lord, on the 5th of October 2022, the SCA dismissed Prince Mbonisi's petition. And on the 22nd of March 2023, the Supreme Court of Appeal sent a notice advising that the Princess's appeal had lapsed on account of failure to timeously file the heads. Just to revert to the grounds on which the SCA dismissed Prince Mbonisi's application for leave to appeal, the grounds were that there's no reasonable prospect of success in an appeal, and there's no compelling reason why an appeal should be heard. Lord, I have referred to the matter that is pending in the SCA, that is Queen Sibongile's. Yes. Now, the applicants have sought to file the heads of argument by the second respondent in that appeal, and this, Lord, is to be found in case lines 029, 78 to 120. And the recusal issue is dealt with within those paragraphs.
On page 34 of those heads.
That is so. Paragraph 111 up to 114. And those heads paint a very strange picture, my Lord. The story being that at the beginning of the proceedings before Justice Madondo, the legal representative of the Queen intimated that they might bring a recusal application, and they required some time to consider whether or not to bring that application. After consideration, and after an application to amend their papers was refused, they decided to proceed with the matter to finality.
And you say the point is that in 86 of those heads, no recusal application was brought before the hearing of the matter,
Yes.
None was brought after the ruling of the court on the validity of the customary marriage relief,
Yes.
or after the dismissal of the application for leave to amend,
Yes.
or on the second day of the hearing.
Yes. Yes. In fact, Lord, that's why you'll find nothing said about the application for recusal in Justice Madondo's judgment.
I think he referred to it.
At the end.
Yes, on page 11, paragraph 22. Under the heading Application for My Refusal, it says the applicant Queen thereafter abandoned her application for my recusal and argued the matter.
Yes.
However, on 17 January, the registrar brought to my attention there was a notice of application.
Yes.
It was enrolled for the 25th.
Yes.
At the time, it was not complete. That's the affidavit.
Yes.
Undertaking for confirmatory affidavit wasn't served. 25 January, no appearance.
Yes.
An inquiry, I discovered had not been enrolled,
Yes.
and that's what he said. So
And
he
that-
didn't deal with the merits or contents thereof, but that's what he said about the procedural.
That is so, and that is what the learned friend, Mr. Masuku, said was pending before the SCA. But as we have submitted, Lord, it has absolutely no bearing on the issues that the Lord has to determine. Now,
You mean both procedurally and on the subject of it?
yes,
It was the presiding over a marriage of a queen issue. It wasn't related to the identification issue.
yes,
And
yes.
there wasn't an application for recusal to say that AJP, because you presided in that matter, you can't hear the royal family's decision or not.
Absolutely, absolutely, yes. And this also appears, Lord, in the judgments in respect of the leave to appeal, application for leave to appeal, case lines 03069. Where Madondo AJP states that there's no recusal application, that no recusal application was filed, and this court did not make a ruling in that matter, for reasons that are also articulated in.
That corresponds
Absolutely.
with the paragraph that I've read from his initial judgment.
Absolutely, yes, yes. Now, now we submit, Lord, that all this conclusively means that Madondo's AJP's judgment is not the subject of any appeal. It has never been overturned, and we submit that it is final.
Can it be final against those who weren't part of the proceedings before him?
Yes, yes, and both applicants were parties.
In the application before him?
Yes.
I see.
Yes, Mother. And we submit, Lord, that that the subject matter of this review is res judicata. Alternatively, it is subject to issue estoppel. The question of succession to the throne was a discrete issue in the consolidated application before Justice Madondo. And the questions that he had to determine included, and I quote, whether Prince Misuzulu was legitimately and appropriately identified and nominated as successor to the late Isilo, and whether there was any dispute as to the Zulu kingship. Issues which are squarely before your lordship. And Justice Madondo dismissed Prince Mbonisi's application on the basis, firstly, that there was no contender to the throne who professed to have a better right, entitlement, or title to succeed than at the time Prince Misuzulu. And that Prince Mbonisi had not made out a case that the identification of Prince Misuzulu as the successor to the throne was not in accordance with Zulu customary law and customs and the provisions of Section 8.1 of the Act, read with Section 17 of the KwaZulu-Natal Act. And this appears, Lord, in the High Court judgment, case number 10879, that is a case brought by Prince Mbonisi. And this appears case line 001.
Well, just give me the reference to the paragraph number in the judgment.
Case lines 001, 170 at paragraph 103.
Yes.
Yes. Regarding the constitution of the royal family, at the meeting of the 14th of May.
Sorry, if I may interrupt you.
Yes, ma'am.
Is your argument then further on an extension of the res judicata issue, that if one were to have wanted to attack that finding in the paragraph you referred me to,
Yes.
or the paragraphs in the application for, in the dismissal of the application for leave to appeal.
Yes.
That's 2.11 and 2.12.
Yes.
Where it says the power to identify and nominate to appoint lies with the royal family, there's no dispute. Then the core members issue is raised and says there was no dispute as to the core structure of the royal family and who constitutes it. Now before me there was argument yesterday as a dispute as to that, and it was actually mentioned that that dispute might even be a long and not easily resolvable dispute, depending on how you structure the descendants or not. Is your argument on the res judicata that if one wanted to attack those findings, then those who should have been who were party to that proceeding should have taken that on appeal, and it can't be done otherwise?
Well, actually, if one has regard to Prince Mbonisi's application for leave, that's exactly what he did. But his application was dismissed. And his application is in the papers before you. Yes.
Now, I'll ask the applicants again that in reply, because on the one hand, it will be inimical to the interests of all concerned if there is a remaining dispute still hanging in the air. And finality, if finality had been reached by Madondo AJP, would resolve that dispute, not leave it hanging in the air. And if the argument is, but if you did not want it to be final, the step should have been taken on appeal.
Yes, in fact, as I say, Lord, there was an attempt to take the judgment and the findings on appeal. If Your Lordship...
Because I can't sit on appeal on what Madondo AJP did.
Absolutely, my
I
Lord.
can only deal with the issues if it can be separated on a res judicata or absence of res judicata basis.
Absolutely. Absolutely, my Lord. And that is our submission. In fact, we submit that there's a presumption that a judgment is correct.
Well, that's the basis underlying res judicata.
Absolutely, yes. And if one wishes to upset a judgment, then what one should do is to take it on appeal and have it overturned. And they attempted to do that and failed.
And will this also apply to Prince Simakade, who wasn't the applicant, although was cited in the matter? Was he? Yes, he was.
Yeah, well, he was cited.
He's cited, but he wasn't an applicant or an active respondent.
No.
But you would say that will also apply on the basis of issue estoppel.
Yes.
That there's an issue in a matter of which you have been cited as a party.
Yes.
If you wanted to raise something, then you must have said something.
Yes. If Lordship will bear with me, I'm receiving some assistance here from my colleague. Yes. In case lines 020189, Prince Simakade actually deposed to a confirmatory affidavit on the 20th of May, 2021. So he was clearly aware of the proceedings, he participated in the proceedings. Yes. May I proceed, my Lord?
Yes, certainly. Thank you.
Yes. Now, I was just about to say that regarding the constitution of the royal family at the meeting of the 14th of May 2021, Justice Madondo found that there had not been any genuine dispute as to the core structure of the royal family, and that a feeble assertion had been made that the royal family meeting was attended by persons who were not members of the Zulu royal family. He further...
Yes, he dealt with that very briefly in his
yes.
decision on the application for leave to appeal. He says, but it matters not. If there are extras, it doesn't invalidate if those who are entitled to make the decision are present.
Precisely.
As I understand his judgment.
Yes, no, we submit, Lord, that is the proper way to understand his judgment. Yeah. And just to digress a bit, we are dealing here with a judge who is steeped in Zulu culture and custom. And we are dealing with Prince Mangosuthu Buthelezi, who was, according to all versions,
the custodian of all that related to the custom. If one wanted to know what the custom is, one would have asked him in life then. That's how it was presented in his affidavit.
Absolutely. And that was accepted by Justice Madondo. So Lord, we have to be careful before we dismiss, firstly, what Prince Buthelezi said and what Justice Madondo found. Justice Madondo further found that the applicant princesses and Prince Mbonisi had not made out a case that some of the people who took the decision to identify and nominate Prince Misuzulu as the successor were not members of the Zulu royal family. Now, regarding whether there was a dispute to the kingship, Justice Madondo found that both Prince Mbonisi and the applicant princesses did not dispute the entitlement of Prince, as he was then, now King, Misuzulu, to succeed to the Zulu throne, and to quote, no such dispute was raised at the meeting or subsequently thereafter, and that it was common cause that there was no contender to the Zulu throne. My Lord, just to digress once more and deal with the antecedents to that meeting of the 14th of May, court will bear with me. Lord, if
Is that the 7 May meeting?
no, my Lord. This relates to a letter which was addressed to the Prime Minister, Ndunankulu, and Prime Minister of KwaZulu, Mtwana wakwaPhindangene, Mangosuthu Buthelezi, and members of the royal family. It's dated the 23rd of March, 2021, and it's found in case line 042, page 251. It's a letter written and addressed to the persons I've mentioned by the late Queen Mandombi. It says, Your Excellencies, successor to His Majesty the King, the task that befalls me weighs heavily.
I'm sorry, Mr. Muranga, just give me that reference again, the one which you got.
Yes, it's 042.
In which application?
Prince Simakade, I beg your pardon. Prince Simakade, yes.
042?
251. 251, yes. Yes. Your Excellency's successor to His Majesty the King, the task that befalls me weighs heavily. After the untimely demise of our King Isilo Samabandla Onke, King Zwelithini, the need to fill up the position of the fallen king has arisen. His Majesty the King, during his lifetime, and through his last will and testament, bestowed upon me the singular honor to succeed him and to assume the role of the Zulu monarch. I hope that the wishes expressed by His Majesty the King to bestow upon me the privilege of being His Majesty's successor will be welcomed and embraced by your good selves. Whilst I'm humbled by the honor and the wishes of His Majesty, I believe it to be appropriate and befitting of the great Zulu nation to bestow the honor given to me by His Majesty to my son, Umntwana Misuzulu Zulu. In this regard, I implore you to give consideration to appointing Umntwana Misuzulu Zulu as the king in my stead. I'm hopeful that Umntwana Misuzulu Zulu will accept this honor and duty with buoyancy. In the event that he does not accede to my wishes or is not appointed, and only in those circumstances shall I oblige with the king's wishes that I should succeed His Majesty. I believe that Umntwana Misizulu is preeminently suitable to assume the position of the Zulu monarch. Umntwana Misuzulu Zulu is a designate heir of the Zulu kingdom in terms of our Zulu customary law and traditions. Umntwana Misuzulu Zulu is the son of His Majesty in the royal house of Kwakhangela Mankengane. God has given me the singular honor to be born from the royalty of His Majesty, the King of Eswatini, Sobhuza II. In accordance with a long-standing tradition of the Zulu nation, the son born of royalty, such as Umntwana Misuzulu Zulu, as preeminently the successor to the king. It will also be remembered that the Zulu kingdom paid the lobolo to the kingdom of Eswatini on the occasion leading to my betrothal to His Majesty the King. This was done by the Zulu nation. Again, and in accordance with Zulu customs and traditions, the first son born of my marriage to the king becomes the successor to the king. Umntwana Misuzulu Zulu qualifies for the appointment as the king. He has no previous conviction. He is of sound mind. He has no disqualifying impediments which militate against his appointment as the king. I accordingly invite Your Excellencies to support my decision and identify Umntwana Misizulu as the person who should assume the position of the king of the Zulu nation. And it is signed by Queen Manfombi Zulu of Kangela Mankengane Royal House. So much, my Lord, for submissions and allegations that there were no criteria when the decision was taken to identify King Misuzulu as king-elect.
Yes, I think Mr. Dodson's argument was, but when the decision was put before the President, these factors did not, in terms of Section 81, form part of that decision to say, here's a decision of the Royal House, and this is why the Royal Family, this is why the Royal Family came to this decision or this identification. I think that was a primary thrust of the 8-1 argument.
My Lord, I believe there was lots of documentation that was placed before.
Sorry?
There's lots of documentation which was placed before the President.
The President?
Yes. Yes.
No, sorry, I'm just responding to your argument to say this is what was said about the qualifications of the king-elect by the Queen and why he should be then considered.
Yes. In any event, when the members of the Royal House met subsequently on the 14th of May, this was all before them. Yes. Now, in respect of the effect of the suspension of the late Isilo's will on the identification and nomination of Prince Misuzulu, Justice Madondo found that Prince Misuzulu was the designated heir and prince-elect of the Zulu kingdom in terms of Zulu customary law and customs, who had been identified and nominated by the Zulu royal family as the successor to the late Isilo. Not necessarily because he was nominated by the late Queen, but rather because the evidence had established that the identification, nomination, and appointment of Prince Misuzulu was not solely dependent on the validity of Isilo's will, as it showed that on the 14th of May 2021, the Zulu family assembled and identified Prince Misuzulu as a successor to the Zulu throne according to Zulu customary law and customs. Lord, this is to be found at case lines 001, 151 to 152, at paragraphs 57 to 58. Lastly, in respect to the applicant's contention that the President and/or the Premier of the KwaZulu-Natal province had an obligation to investigate or refer the matter back to the Zulu royal family for consideration and resolution, Justice Madondo found that Princess Thembi Ndlovu's letter addressed to the President did not comply with Section 8, subsection 4 of the Leadership Act. He emphasized that, and I quote, that the President should act where there is evidence or an allegation that the identification of a person as king or queen was not done in accordance with customary law and custom. No such evidence or allegation has been brought to the notice of the President in this regard. The letter of Princess Thembi Ndlovu lacked the necessary allegation that Prince Misuzulu, who was identified by the royal family, had not been identified in accordance with Zulu customary law and traditions, and that Prince Simakade has a better right or entitlement to the throne.
But apart from the better right issue, Advocate Dodson will, if you ask him this question, say, but of course the learned justice was wrong. We've shown your lordship the documents of Princess Thembi, and we've shown your lordship the extensive allegations of disputes, referring almost to a legal treatise. And therefore that fact appears to be wrong, but your argument might then be, but even if it is wrong, that was the finding. If you want to take it on appeal, take it on appeal.
Absolutely. Absolutely. And in any event, Lord, we submit that thesis in the first place.
Mr. Marani, while you're looking for a paragraph or a page there, will it be convenient to take the adjournment now?
The customary adjournment, yes.
I see you were just, so might I grasp that moment?
Carpe diem.
Court will adjourn.
Word, feeling fine.
Fantastic.
I feel like I'm on the road.
Yeah. I think you're because it's kind of thinking about these issues like, okay, what about this? And remember yesterday you felt like he was with them.
Oh yeah, I know.
But I think you're putting it back. Also, I think our arguments are so easy. They're devoid of like theatrics. It's really just this case says this, the case line here. Let's just get to the point.
I just received a note from a colleague of mine.
Yeah?
He says there's no way you're losing this one.
He says this.
Oh, he's
Lucky I got you tea there, Sylvia. I got her tea.
and the minister's arguments. We submit as a general proposition that there was a valid identification and application in terms of Section 8, 1A, Roman 1 and Roman 2 of the Act before the President. And we submit that the matter is res judicata. And on the merits, we submit that the applicants correctly contend that an application for recognition by the royal family is a mandatory procedural and substantive requirement without which the President cannot lawfully exercise his power to recognize a person as king of a kingdom in terms of Section 8 of the Act. But we submit that the applicants incorrectly argue that the impugned decision violates the principle of legality. The starting point for the President in respect of the issue of the identification.
Sorry, Mr. Morani, I'm just distracted. Thank you. Yes, you submit that.
That's the starting point. For the President, in respect of the identification and nomination, is the letter of the 12th of March, when he received an application for the recognition of the then Prince Misuzulu.
You say that letter constitutes the application?
Yes, my lord. And that application was submitted by the late Prince Mangosuthu Buthelezi as Prime Minister of the Zulu nation on behalf of the royal family. And in terms, we submit, of Section 8.1a, Roman 2 of the Act. And we submit that on receipt of that application, the President was entitled to rely upon the representations of Prince Mangosuthu in his capacity as Prime Minister of the Zulu nation. And we further submit that the President was bound by Justice Madondo's findings. That included that Prince Misuzulu, as he then was, had been both identified and unanimously nominated as King of the Zulu nation in accordance with Zulu customary law.
All right, but the letter from the late Prime Minister was 12 March.
Yes.
And there were steps since then, before we jump to the point where you say the President was entitled to rely on the determination by Madondo AJP.
I don't follow. What steps, my lord?
So what happened after you received the... Oh, you mean the later letter already was after the judgment of Madondo AJP, and the combination thereof is what the President was entitled to rely on?
Yes.
I have now received the letter, and I've gotten a court judgment which says this is the position, the same as in your letter.
That is so. That is so. Yes. Yes. Now, the reasons that underpin that finding of Justice Madondo includes the following: that the ilobolo for the late Queen Mantfombi was paid for by the Zulu nation because she was the daughter born of a royal family. And Prince Simakade had disavowed any
If that happens again, the person who causes it shall not be entitled to remain in the court.
secondly, my Lord,
sorry for the interruption.
my Lord, please. Secondly, that Prince Simakade had disavowed any entitlement to the throne. Prince Buthelezi, who was judicially recognized by Justice Madondo as the only person authorized to convene such meetings of the royal family, advised the president of four things. Firstly, that the Zulu royal family had recognized Prince Misuzulu as successor to the throne in accordance with Zulu customary law and traditions. Secondly, that the recognition took place at the 14th of May 2021 meeting. It was unanimous. No query was raised, and no grievances were lodged. And thirdly, that the announcement of the succession of Prince Misuzulu to the throne was not unexpected, as it had been understood from the time of the late king's marriage to the late queen that the king's heir would come from the house of Queen Mantfombi. Lord, as far as that is concerned, it appears we are ad idem with Prince Simakade. Although he identifies himself as the correct son and not King Misuzulu. Yes. And fourthly, on the 29th of September 2021, the royal family convened at Kwakangela Mankengan and took several resolutions which were attached to the recognition application recognizing the then Prince Misuzulu as king. And this appears, Lord, at case line 020198. That's part of the Rule 53 record. Because in accordance with the provisions of Section 3, sub 2A and B of the Act, the application for recognition must be accompanied by a resolution of each traditional council referred to in Section 1, subsection B of the Act. We submit that that requirement was complied with. Now, that resolution recorded that the royal family declared that it had recognized Prince Misuzulu as the present king of the Zulu nation. We submit, Lord, that the decision was therefore valid and did not violate the principle of legality. The applicants submit and allege that the president abdicated his power to the minister, in particular Prince Simakade. He argues that the impugned decision be declared unlawful because the mediation panel appointed by the minister pursuant to the president's request was not a lawful investigation under Section 8 of the Act, as it cannot replace the legal requirement on the president to institute an investigation as opposed to a mediation if there is a succession dispute, so they allege. We submit that that contention is misplaced. The ad hoc mediation is not an investigation committee. Yes.
It's not an 8-4 committee.
Absolutely.
Which is also part of the complaint.
Yes.
But the complaint, as I understand, goes further. Even if you, as president, now want to mediate a dispute such as this in the interests of all involved, and you get that report, and if that report is not yet conclusive, aren't you then obliged, in terms of the Act, they say, to appoint a committee?
We submit not. The applicants are relying on two sections. They rely on Section 8.4, read with 8.5, and they also rely on Section 59 of the Act. Dealing first with Section 59, we submit that Section 59 deals with the situation after a king or queen has been appointed. Then any dispute that arises thereafter has to be
dealt with under Section 59. It appears to be so because it is of general application.
Absolutely.
And 8 deals with the first appointment and recognition.
That is so.
First time, yes.
That is so. But Section 8.4 relates to a specific matter, and the jurisdictional facts are that there is an allegation or evidence relating to
You'll have to turn off aeroplane mode.
Lord,
I suggest the attorney then takes the instruction and not just to turn off airplane mode, but to turn the phone off completely. Yes, all right, so it's a very low threshold. If we put aside the issue of evidence, it's a low threshold. If there is an allegation of a dispute, if someone comes to say, look, it wasn't the Corwell family, it wasn't a decision, there wasn't a nomination, it was purely an announcement by the late Prime Minister, it's an allegation of improcedural or without outside the customs decision. So it's a low threshold, and then Mr. Dodson and Mr. Masuku said, and that's been met.
With respect, we disagree. We disagree. Because in terms of Section 8, subsection 4, it has to relate to something that was not done in accordance with customary law or customs. If it's just a dispute about a certain preference, etc., it is not one that is done or is not done in terms of customary law and custom. In fact, that is a finding of Justice Madondo in the paragraph to which I referred, Your Lordship, 101, where, as I submitted, he comprehensively dealt with that situation. Case line 001169, paragraph 101. In that paragraph, he comprehensively dealt with the correct interpretation of Section 8, subsection 4, and Section 8, subsection 5.
Is that what you say he found or meant when he said the letter that Princess Tembi and Glovo addressed to the President stating there was a disagreement in the Zulu royal family that who should succeed to the throne between Prince Misuzulu and Prince Simakade did not comply with the provisions of Section 8.4?
Precisely.
If it's a preference issue,
Yes.
it's outside the Act.
Precisely, my
It
lord.
must be a dispute regarding the correctness of the customary law or the customs or the application thereof.
Absolutely. Absolutely. That is our submission. And that is, we submit a jurisdictional fact for invoking those two provisions, 8 sub 4 and 8 sub 5. Where he says, there's no genuine dispute as to the succession of Prince Misuzulu, as he is, in terms of the customary law and customs, the rightful heir to the throne. No one has disputed the correctness of the customary law and customs by which the name of Prince Misuzulu was raised and endorsed by the royal family. The applicant princesses and the applicant prince, neither in their founding affidavit nor in their supplementary and replying affidavits, have made any assertion that the appointment of Prince Misuzulu was not in accordance with Zulu customary law and traditions. The letter...
Mr. Morani, let's just deal with this now once and for all. Will everyone who wants to attend the court switch their phones off? As almost with an airline, I give you now the opportunity to do so. Before we take off the argument further. The interruptions are distracting both counsel and myself. It's improper, it's disrespectful to him and to the court. Mr. Morani, sorry, where were you?
As Lord pleases. I said that the applicant princesses and the applicant prince, neither in their founding affidavit nor in their supplementary and replying affidavits, have made any assertion that the appointment of Prince Misuzulu was not in accordance with Zulu customary law and traditions. The letter that Princess Tembi Ndlovu addressed to the President, stating that there was a disagreement in the royal family as to who should succeed to the throne between Prince Misuzulu and Prince Simakade, did not comply with the provisions of Section 8, subsection 4 of the Leadership Act. The President should act where there is evidence or an allegation that the identification of a person as king or queen was not done in accordance with customary law and customs, quoting the verbatim of the Act. No such evidence or allegation has been brought to the notice of the President in this regard. The letter of Princess Tembi Ndlovu lacked the necessary allegation that Prince Misuzulu, who was identified by the royal family, had not been identified in accordance with Zulu customary law and traditions, and that Prince Simakade has a better right or entitlement to succeed to the throne. More so, it is common cause that Prince Simakade declined the nomination. As a result, he is not a contender. Even if he purported to accept the nomination, he could not have legitimately been identified, as he does not qualify in terms of Zulu customary law and customs. Prince Simakade's purported identification was accordingly doomed. The applicant has therefore failed to make out a case that there is a dispute about the successor to the throne on the basis of which the president or the premier may investigate or refer the matter back to the Zulu royal family for consideration and resolution. Those are our submissions. Justice Madondo was correct in his interpretation of those provisions in the light of the evidence before him. There are also other references, Lord, case lines 029, 57. Those are paragraph 176 and 179 of the President and Minister's answering affidavit. The conclusion of that submission, of these submissions, my Lord, is that the President did not abdicate his power to the Minister. Now, I'll move on to the next heading, which I've effectively dealt with. The heading, Lord, being that there was no dispute lodged before the President in terms of Section 8.4 of the Act.
Yes, you've actually now addressed this by way of Judge Madondo's judgment.
Absolutely. Yes. I don't need to belabor the point. I don't need to repeat it. Except, I suppose, to highlight my Lord, a number of factors on which the President relied arising from Justice Madondo's finding. Firstly, that Prince Mbonisi had failed to make out a case that there was a dispute about the successor to the throne, on the basis of which either the President or the Premier could investigate or refer the matter to the royal family for reconsideration. And that, secondly, both Princess Mbonisi and the applicant princesses did not dispute Prince Misuzulu's entitled to succeed to the Zulu throne, and no such dispute was raised at the meeting or subsequently thereafter, and that it was common cause that there was no contender to the Zulu throne. This is case lines 01628 and paragraph 55 of our heads of argument, and that on the 11th of May, Prince Simakade had addressed a letter to Prince Mangosuthu Buthelezi requesting that the letter should be read out at the Zulu royal family meeting of the 14th May 2021. That's paragraph 56 of our heads, case lines 01628. D. The upshot of his letter was his disavowal of any claim to the throne or any intention to claim it. He instead indicated his willingness to abide by the decision of the royal family. same reference case lines. Madondo AJP emphasized that if anyone had disputed Prince Misuzulu's identification and nomination, he should have done so at the royal family meeting where the matter was discussed. Next point. It's actually just to encapsulate what I've already said. Princess.
The two, however, who would have raised that issue at the meeting of 14 May, Prince Mbonisi and Princess Tembi, were both absent. They'd sent their apologies.
Yes.
Yeah.
Yes. Then they mustn't complain if they're invited and did not present themselves. I've already dealt with the fact that Princess Tembi's letter did not comply with Section 8.4 of the leadership, etc. I don't need to belabor the point that there was no dispute for the Premier or President to investigate. Just a reference to case lines 01643. Then we conclude, Lord, that the judgment therefore laid to rest the issue of any dispute having been lodged with the President. The next topic I wish to deal with is that the President was not bound by the recommendations of the mediation panel.
Sorry, the topic that?
That the President was not bound by the recommendations of the mediation panel.
But is there a dispute about that?
I don't know. But just for completeness' sake, my Lord, in case somebody in reply says there's a dispute.
But he can't be bound.
Of course.
It was firstly a mediation panel, and at best it was an extension of his letter to the minister to ask for it to be advised.
That is so.
But of course, he is free to use or ignore the advice.
Absolutely. Absolutely. Yes, but I think Prince Simakade.
In fact, in terms of the structure of the Act, even if there had been a committee in terms of 8.4, he would still not necessarily have been bound. He must just have been very circumspect in producing reasons why he did not follow such a recommendation if there had been one.
Yes. Yes. The only reason why I'm raising this, Lord, is that it is actually disputed by Prince Simakade, who submits that the decision by the President was unlawful because, without reason, he failed to follow the recommendation of the mediation panel that no decision to recognize Prince Misuzulu be taken pending a full investigation into the heir to the Zulu throne. That's really why we are making that point. But I take his lordship's point that in any event, these were recommendations. He was not bound. But for fullness' sake, I just refer to case line 02956. The next topic I'm dealing with, Lord, is that Prince Simakade was not entitled to a hearing prior to the impugned decision. This is based on the contention by Prince Simakade that the president failed to afford him a hearing before the president made the decision. And we submit that the report from the panel was not intended to be shared or debated with the royal family. Instead, the minister had appointed the panel in order to attend to the concerns raised about the AmaZulu kingship and its succession. And they made recommendations.
This was raised on the papers, but I can't recall Mr. Dodson actually pushing this point firmly as a separate ground for review.
My Lord, the only reason we are raising this is because of what Prince Simakade said in his papers.
He said in his papers, yes.
Yes. So we don't want to be accused of not having dealt with these allegations.
You say in his affidavit he said he was entitled to be afforded a hearing prior to the decision being made.
That is so. Yes. Yes. Well, we conclude that the legal consequences of affording parties an opportunity to make representations or comments did not accrue to Prince Simakade. Therefore, the President's conduct did not amount to procedural unfairness, in that there's no provision in law that obliges the President to act in that particular manner. Briefly, the next heading, Lord, which I don't need to belabor, is that the suspension of the late Isilo's will has no bearing on the identification and nomination of King Misuzulu. As I say, I don't need to belabor that, except to record that Justice Madondo stated that Prince Misuzulu was, quote, the designated heir and prince-elect of the Zulu kingdom in terms of Zulu customary law and customs, who had been identified and nominated by the Zulu royal family as a successor to the late Isilo, not because he was nominated by the late Queen, but rather because the royal family had identified and nominated him at the royal family meeting to be the successor to the Zulu throne, and no dispute had arisen in that regard. The next topic, my Lord, is I'm dealing with...
At best, the late Isulu's will and the validity thereof might impact on the late Queen's appointment or not, and then whether she was a successor or then later only in the meeting found to have been appointed as a regent because the will was contested. But there's no reliance by Madondo AJP on the contested will as conferring a delegation to nominate.
No. And in fact, I think he specifically states that issue is irrelevant.
Yes. And
yes.
From the letter that you referred to in any event, it appears as if she made an independent nomination.
Yes. That is so. Yes. Now, the next topic, my Lord, is that the President's decision was neither irrational nor arbitrary. Now, the applicants contend that numerous attempts were made by the first applicant, that's Prince Mbonisi, that's right, on behalf of the royal family to halt the formal recognition of the then Prince Misuzulu by the President, which they say were ignored by the President. They also contend that the President's failure to address or acknowledge the inquiries and letters of Princess Thembinhlovu and Prince Mbonisi amounted to a failure to give a hearing when he had a duty to do so, and therefore this failure resulted in the President making an irrational decision that fails the test of legality. There's a huge jump in logic there, Lord, which is not sustainable. In any event, Lord, it's common cause that Prince Mbonisi brought several cases which he lost, all of them without exception. Even when he tried to appeal to the Supreme Court of Appeal. So we submit that in this regard, the evidence showed that the President received the letter from Princess Thembi on the 3rd of June, which was found to lack insufficient allegations and evidence to constitute a dispute in terms of Section 8, Subs 4, as found by Justice Madondo. One matter which we wish to draw your Lordship's attention to is that the document which was handed up yesterday by my learned colleague, Advocate Dodson, that particular document was never received by the President or the Presidency in that form. Is it this document?
If you say in this form, was received in a different form? Because she refers to it in a letter.
Yes. When it's alleged that it was sent, apparently it was sent in this form with the coat of arms, etc. And it's.
But let me just get your submission clear.
Yes.
Was the letter annexed to her letter sent to the President? And if it was, is the question then simply was it in this form or in a different form or in an unclear form?
Firstly, Lord, it was not received on the 28th of May. Let me put it that way.
All right. When was it received?
On or about the 3rd of June. And
right, so this letter,
yes,
perhaps in a erroneous form, with the coat of arms imposing on the letters, you say was sent, was received not on the day, the date thereof, but on the 3rd of June.
Yes.
All
yes.
right.
And the reason for that, Lord, is that it has a wrong fax number, firstly, and a non-existent email address.
If it was sent separately.
I beg your pardon.
If it was sent separately.
It was, yes.
Yes. But if it was sent as part of a letter, as an annexure?
At a later stage, yes, my Lord. But not in
But what's the point then? The point is he didn't receive it in this form at this date. He only received it as an annexure or a erroneous copy at a later date.
That's all, my Lord. I'm not making much of it, except just to point out that on this document, which was handed up tomorrow, it bears a non-existent email address. In other words, president@presidency.org. OV.
I mean, there's a G missing.
Absolutely, yes, yes.
So, but all one knows is there's a G missing on this document. It might then be, if it's been sent to the missing G email address, it might not have been received. But my question was that if it was received later, then what's the point of that?
No. I'm not making anything of this. I'm just correcting
I see. All right.
something minor, my lord. It's not major, and as I say, we are not really relying on that. Yes.
All right, but if you're not relying on that, then Mr. Dodson says, but once you receive this extensive document, yes, a substantial portion of it deals with the will, but then later thereof, it refers to the identification decision. And as I understood his argument to say that this at least then qualifies as an allegation threshold in triggering Section 8 sub 4.
Lord, it might be an allegation, but it is not an allegation relating to what was not done in terms of customary law.
So you say even if this was then incorrectly sent on the 28th of May, but was then later eventually received by the President on the 3rd of June.
Yes.
Even if one has regard to the totality of this document, you say the comment still stands as you say, Justice Madondo found, this does not elevate the allegations to that qualifying for Section 8.4.
Absolutely, my lord.
It does not impugn the process in terms of the customs.
Yes. Yes.
Yes, you said yes, but your junior also pointed to something. Are you saying yes to me or yes to her? But is that how I must understand the submission?
To both of you.
To both. Right. So I understood the submission then correctly.
Absolutely. Yes. Now, the only point that my junior was making that it was also before Justice Madondo.
Was also before Justice Madondo.
Yes. That's the helpful thing she was doing. Yes.
Yes. So that's a further extension of that submission, so that even though it was not received on 28th, it was received on the 3rd, it was before the President. But it was also considered by Justice Madondo. We came to the conclusion that even this and Princess Thembi Ndlovu's concerns did not meet the threshold.
Absolutely. That's our submission.
That's right.
Yes. Yes. Lord, even momentarily putting aside the judgment of Justice Madondo, the President on the 16th of August 2021, subsequent to having received correspondence from various members of the royal family, directed the minister to attend to the matter and advise him on his concerns surrounding the nomination. Lord, with regard to Prince Mbonisi's letter addressed to the President dated the 21st of February 22, it must be noted that this was received 3 days after the minister had advised the President to firstly wait for the court cases to conclude before proceeding with any other action. And the advice also was that what needs to be done will be much clearer after the judges have pronounced on the issues challenged. In other words, what the panel and the minister advised was that these issues will be much, much clearer after there's a judgment by the court. And this is to be found, my Lord, in case lines 026, 46. And the minister also advised, the minister and the panel advised the president to closely monitor the judgment on the interdict against Prince Buthelezi and the king-elect from purporting to have a king in place in the midst of contestation and dispute challenged by the backers of another nominee. And thirdly, first investigate through a legally formed investigation team before recognizing any person. Well, with regards to Prince Mbonisi's letter dated the 9th of March, notwithstanding that it was received subsequent to the handing down of Justice Madondo's judgment, we highlight that that letter specifically advised that, and I quote, "For as long as there are legal proceedings over the validity of the meeting of the 14th of May 2021 and the selection or identification of Prince Misuzulu Zwelithini Zulu, the President should not endorse any application and submissions made to him by anyone in terms of Section 81A, Roman 2 of the Act for the recognition of a person as king of the Zulu kingdom." Well, the judgment and orders of Justice Madondo make it clear that after the 2nd of March, there were no legal proceedings in respect of both the validity of the meeting of the 14th of May and the selection or identification of Prince Misuzulu. He was therefore at liberty to endorse the application and submission made in terms of the statute by Prince Mangosuthu on behalf of the royal family on the 12th of March. The President's decision was therefore based on Justice Madondo's findings that the royal family, at a meeting on the 14th of May 2021, had identified then Prince Misuzulu as the successor to the royal throne. Secondly, that in accordance with Zulu custom and tradition, the customary law, and that there was no genuine dispute as to the succession of Prince Misuzulu, as he was the rightful heir to the throne in terms of customary law. And that appears in the President and Minister's answering affidavit, case lines 006, 85. And we submit that the ad hoc committee's recommendation that the President ought to first investigate through a legally formed investigation before he issued a certificate of recognition fell away upon the handing down of the judgment, as both prayers interdicting the President from doing so were dismissed, together with the applicant Princess's prayer, directing the President to refer the matter concerning the identification back to the royal family for reconsideration and resolution. Our conclusion, therefore, Lord, is that the President's impugned decision was neither irrational nor arbitrary. In fact, we submit that it was a decision that a reasonable decision maker could have made. Our final topic, my Lord, is that the President did not fail to apply his mind We submit that all the submissions that we have made demonstrate.
After your previous submission, that's almost implied. If you said, look, it wasn't irrational and wasn't arbitrary, it was a decision which a reasonable decision maker could make. Now, if a president made such a decision, it almost implied that he must have
applied his mind.
Yes.
Yes. Yeah. That is so. That is so. But I think these are just concluding remarks, Lord. And to say that the following conduct on the part of the president and the minister that illustrates this. That firstly, they set up this ad hoc panel and commissioned the panel report. And in respect of Prince Mbonisi's letter, Justice Madondo makes clear that from the 2nd of March, I withdraw that submission. I've already made it. That
you probably want to say something about costs.
Firstly, before I say anything about costs, I want to conclude on just an equitable remedy.
All right. Well, let's debate that then, because Mr. Dodson also said that the respondents should address the issue. What if this court were to find that the judgment of AJP Madondo was not res judicata, and what if there is then an order setting aside the recognition decision? What should the consequence there be? And that's the remittal in paragraph 4 of their draft order, so that the section 8.4 process can be followed. Do you have a copy of the draft?
Yes, sir.
So when you now get to just and equitable, they say, well, just and equitable is, they'll think about prayer 1, but paragraph 2, if the recognition decision is set aside, then what should then be the consequence? And the Prince Simakade's suggestion is then paragraph 4, a section 8.4 committee process.
Yes. Lord, we obviously have not applied our minds to this draft order. But all we are saying at this stage is that if, in fact, is...
Yeah, but this was his argument yesterday as well. So look, that is what should have happened. This should have met the threshold of Section 8.4. It's an allegation, at least. The President was obliged, mandatorily so, to take that route, and he hasn't. So if one wants to reverse a part of the process, at least go back to where he has now received the decision, the identification decision, and it should have followed this route. This order just formulates that, borrowing from the alternate in paragraph 10.1 and 10.2 of the previous amended notice of motion.
Yes, my Lord. we received this draft order this morning just before proceedings started, and we have not really applied our minds to it. All I can say, my Lord, is that if the court is against us, then Section 172, 1A of the Constitution gives the courts the right, discretion, the power to make an order that is just and equitable in the circumstances. And one of the orders that the courts could make, although I'm speaking without any instructions here, would be a remittal to the decision maker. I know that part of it is encapsulated in the.
Yes. Do you mean a remittal without an indication that he should be compelled to follow Section 8.4? Just a pure remittal? Or a remittal as claimed here with a direction? You see, one can set aside the recognition decision and then remit it to the President to reconsider. The applicants, or Prince Simakade says, no, don't only remit and direct the President to act.
My Lord, as this would affect the powers of the President, I wouldn't like to venture an opinion without clear instructions.
Shall you prefer we take the lunch and adjournment a bit earlier? No, it is 22:1. So it will be an additional, not long, but time to take an instruction. Or you can come back after 2 and say, look, I've taken instructions too short. I need more time. And then I'll hear Mr. Pakran, and then we can deal with it thereafter.
Perhaps, my Lord, that is the appropriate course to follow.
Yes, well then, I don't want to prejudice any party.
Yes, yes.
All right. On that note then, court adjourned.
You're absolutely right. I have to have firm instructions. Just come again. dismissal of both applications with costs.
Including cost of multiple counsel.
Of multiple counsel, yes.
Yes.
As a court says.
Thank you.
May it please your Lordship. My Lord, may I, with great respect, coin a phrase which may even become a legal maxim, and that is that courts are there to resolve a dispute, not to create new disputes. Now, my Lord, as I'm about to demonstrate to your Lordship, if one looks at the draft orders which are sought by the two applicants in these two applications, we are bound to have further court applications because nothing is decided. My learned friend, Mr. Dodson, even said yesterday, I was a little surprised that they would have to approach perhaps a court to decide on what really constitutes the royal family as defined in the Act. Now that's the last thing one wants. I mean, we have 6,000 pages here, and we have a judge of the High Court, and we ask your Lordship to decide these issues, whether for us or against us. Nothing should be left hanging in the air. My Lord, I always preface my argument, as your Lordship knows, by saying I'm not going to read my heads of argument, but we stand by what we've said in them. I am going to refer to some of the authority cited in our heads, but I will come to that in due course. I'd like to begin, just perhaps by looking at the Act, without peering too closely at the definition. The definition of royal family is, with respect, somewhat ephemeral at the edges. Talks about close relatives.
It was perhaps formulated to cater for all various permutations in various royal families.
It is deliberately wide and vague, and it is at the interface between constitutional legislative enactment and customary law. So the customary law takes its guidance from the enactment in terms of the Constitution and applies the customary rules and law to that. So one is not going to be guided by the Act as much as one is going to be guided by customary law as to what things such as the royal family mean. Now, the second point is that you will have seen that in terms of the Act, steps must be taken to arrange for the succession of a king, in this case, within 3 months. I suppose the principle is the king is dead, long live the king. The nation should not be left rudderless for any length of time. These things must be decided as expeditiously as possible. And that's just trite. And they should not be permitted to drag on. And I think your Lordship will then, if there is any discretion or any question of equitable relief at the end, your Lordship will be guided by that consideration as well. The next topic will be a simple debate on the draft orders. Well, the draft order in the case of Prince Simakade and the order in the notice of motion by Prince Mbonisi. To take Prince Simakade's draft order first, you might have seen that what our learned friends have done is to compress the old paragraph 10 into 4. They've conflated it into 4. But you will remember that the old 10 was in the alternative. And in the alternative it made sense. This, following on 1, 2 and 3, makes no sense whatever. Because as I'm about to demonstrate, 4 and 1 are antithetical to each other.
Sure, but you recall my question to Mr.
Yes, I
Dodson.
do.
So if one were to ignore 1 and 3.1, might 4 then still follow?
Yes, Lord,
Because I can't see how 4 can follow on 1. Because 1 is the trigger event for 4, if one can call it now the paragraphs. But I mean, the identification decision is the trigger event, if it qualifies, then for the exercise of the obligations, or the exercise of the performance of the obligations under Section 8.4.
I'm simply trying to answer the exact question your Lord proposed by agreeing with you. It is, of course, quite clear that if one is granted, there's no task to be performed by the investigative committee. So that can never be granted. Lord, I'm not going to read to your Lordship the lengthy, very lengthy matters of motion in the Mbonisi application, but one thing is for certain. Despite the fact that the two applicants cozied up to each other on the question of costs, and despite the fact that Prince Simakade in his affidavit suggests that there's not much of a chasm between the two on the issues, and as best they tried to paper over the cracks, there is a vast difference between the two approaches. And again, I use the word antithetical. The relief sought in the Mbonisi application, which you'll find at 001 hyphen
8.
yes, commencing at 7, is all based on, of course, we say, the erroneous proposition that the royal family is that select group of persons which is defined in the founding affidavit. So the two cannot live together. And whilst my learned friend Mr. Dobson amusingly referred to the rugby metaphor of kicking the ball backwards, what he didn't say is what he should have said, and that is that he asks for the Mbonisi application to be dismissed. Never mind about the costs for a moment. But your Lordship would have to dismiss this application, that is the Mbonisi application, in order to grant the Simakade order, and of course vice versa. They cannot live cheek by jowl.
Well, paragraph 4 of the Mbonisi notice of motion accords with paragraph 2 of Prince Simakade's draft order.
Yes. But what flows from that? You see, my Lord, this is why I say one doesn't want to spawn further litigation.
Yes, no, look, if they contest each other if on Prince Simakade's application there's no review of the identification decision, then that is in direct conflict with Prince Mbonisi's application, which is that's where one should start and delete that, or review and set that aside.
All that Simakade says, Prince Simakade says, by the way, Lord, if I slip and I dropped the Prince, forgive me, I mean no disrespect.
I saw in the heads that the references to Simakade and Mbonisi was made just for identification purposes without implying any disrespect by not using the full title. So if you do slip, then those implicated should take it like that, as mentioned already in the heads. I will as well do so.
Thank you. But my Lord, whilst the destination, ultimately the review of the decision of the President may be the same. The path by which one attains that is completely different, and the two are mutually exclusive. Now, I'd like to revert for a moment to my learned friend Mr. Dobson's draft order, and more particularly his recent notification that he is not persisting with the substitution in phrase 8 and 9. Now, Lord, it's a magnanimous gesture, but I'm always afraid of Greeks bearing gifts. I don't know where the Trojan horse lies, and I'll explain to your Lordship why. If one looks at this draft order, Prince Simakade is not mentioned here anywhere. Now we know from the papers that there is a massive dispute about whether or not he is a candidate to the BBA. And what's more, there is a dispute about the propriety of the meetings, I think on the 5th of May and the 23rd of May, at which Prince Simakade's name was put forward for nomination. Now, Lord, I trust that it is not the intention of Prince Simakade, once, if your Lordship is minded to grant the relief in this draft order, that one is simply going to get by the back door what you have said you are, in fact, abandoning by the front door, namely the substitution.
Well, might it not be that he is not claiming a substitution by way of a court order without abandoning any other, as he put it in his letter, I did not covet the position, and I'm respectful to my siblings and the others, but if nominated, then I'll accept.
Well,
and is it not then that that issue is one which formed part of the allegations to be examined whether that was even considered during the identification meeting, as I understand the argument? So I hear what you say, backdoor in, but it might be a backdoor in because of a different foundation, not by way of court order, but by way of custom.
No, but the point that I'm making is that he has, in his words, and according to his argument, been nominated the 5th and the 23rd of May. And what would happen, for instance, if the day afterwards, again assuming that your Lordship is minded to grant the they apply to the President for recognition? There's absolutely nothing to prevent it.
Yes. I hear what you say. I did not understand the order to envisage that that would happen.
Well, that's why I say it's the Trojan horse. And it was not made clear by Mr. Dobson what the position of Prince Simakade would be in this order.
All right, so
Dobson suggested that the whole issue of the candidatureship of Prince Simakade was now no longer an issue in this case. We say it is very much an issue if there is going to be any attempt to pursue it. And I will then have to address you and demonstrate on these papers that he could never aspire to ascend to the throne because of customary law.
all right, but do you need to address me on that? Because do I need to consider that if one has regard to the other principal argument to say that how the nomination which was made to His Majesty the current king, the king-elect then, came about was wrong and not in accordance with custom, irrespective of whether they were contending nominations or not?
Well, one of the issues in this case which has traversed 700-800 pages, is whether Prince Simakade is a candidate for the heirship. And if we're going to just ignore that altogether, it's an issue which hasn't been decided. Decided by His Lordship, Mr. Justice Mdondo,
Yes.
not by your Lordship. And we would ask for at least an indication on these papers. Otherwise, it's just going to come up again.
Perhaps the shortest route would be to ask for clarification of those who withdraw those paragraphs.
Well, I was going to suggest that we might ask my learned friend to clarify what the situation is, and that is his client.
Yes. Mr. Dodson, once paragraphs 8 and 9 of Prince Simakade's application was not proceeded with, what about this question whether it will feature again in part of the Section 8.4 investigation? Will it not? Do we have to then, because if it might, then Mr. Pakran says one has to decide whether it will be a valid contention or not.
The entire debate about whether custom identifies either Prince Simakade or Prince Misuzulu as king is a matter that is strictly to be left for the investigative committee. There is certainly no suggestion from our side that we should spike somehow that inquiry through these proceedings.
Yes, but
Any sort of fine, when we say that we're not proceeding with 8 and 9, yes, certainly those would require a...
by way of a court order, a substitution order,
Indeed,
that falls away.
that falls away.
Yes.
And with that, any need whatsoever to determine which way custom points in favour of either candidate. And in fact, it would be inappropriate for this court to preempt the President's decision. The solution is to be found.
You mean the committee's decision?
The committee's decision. The committee's decision. The principle, starting point in administration is one of deference. And on the basis of the principle of deference, that's an issue that should be left to be investigated strictly. And the moment that we abandoned the exceptional form of relief,
It is only limited to the fact that you don't want a court to order such substitution, or you're not insisting thereon. It doesn't mean a waiver of any other rights in terms of customary law.
either a waiver, more essentially an assertion in these proceedings. So, my learned friend can rest comfortable that there will be a completely fair and open dispute that will be left for the investigating committee. Because of the fact that we haven't gone the extra step of seeking the exceptional relief.
Thank you.
Quite a satisfactory answer, and I'll explain to your Lordship why. Bear in mind that my client's identification will have been set aside.
No, recognition.
Identification. 3-1.
No, but that's what I said.
Oh, I see.
1 and 3-1 can't stand if there's an order in terms of 4. So 1 and 3-1 must fall
Your
away.
Lordship did say 3-1.
Yeah, yes.
Yes.
Because 3-1 is actually just a repetition of
I've heard
1.
what my learned friend said, and there are enough microphones here and enough recording devices to repeat that a dozen times. I'm sorry, Lord, I didn't mean to increase your Lordship's insomnia by raising that, but at least your Lordship won't lose any sleep over it.
It appears to be a minuscule part of the remainder, which might cause a lack of sleep, but thank you.
Now, my Lord, may I turn to the issue of res judicata? And I certainly am not going to repeat what my learned friend, Mr. Marani, and without in any way being patronizing, has argued exceptionally well in my particular case, that there are perhaps just a few issues which I may address, which may be of assistance to you, Lordship. We have dealt with all of them fully in our heads of argument. The one point that I should like to make, which is an overarching point, is that my learned friend, Mr. Dodson, with respect, we were flattered by his suggestion that our argument on res judicata at least made them appear a bit more closely at the law again. We suggest perhaps they didn't appear closely enough, because the refrain which keeps coming out in my learned friend's argument is an identity of cause of action issue and of course the parties. But that's no longer the law. And of course that's the whole question of the extension of res judicata, not into the English law of issue estoppel, but it's just a handy label for an extension of res judicata. That was explained by Pretoria in the ABSA case. So it is no longer an absolute requirement that there be identicality between cause of action and the parties. And I'll give you Lordship now the references to those cases. First and foremost, if I may refer you to our heads of argument 031-14.
I'm there.
Sorry, 031.
I'm there, yes.
Sorry. Well, I'm going to the footnote. Smith versus Porritt, of course, is the leading case, and your Lordship has the reference there. And then, of course, there's the ABSA Bank case. That's the judgment of His Lordship, Mr. Justice Botha. And we say in 8.3, the same party requirement has also been relaxed over the years. The requirement not only extends to the identical individuals or entities who are parties to the proceedings, but also to persons who are in law identified privies to one another. And then there's the Caesar Stone case, which my learned friend also relies upon, where His Lordship, Mr. Justice Wallace, expounded the rule even further. And let me read that to your Lordship. Subject to the person concerned having had a fair opportunity to participate in the initial litigation, where the relevant issue was litigated and decided, there seems to me to be something odd in permitting that person to demand that the issue be litigated all over again with the same witnesses and the same evidence in the hope of a different outcome, merely because there is some difference in the identity of the other litigating party. Now, my Lord, when we get to
And
the
you
facts,
say before Madondo AJP, Prince Mbonisi was a party,
yes,
and Prince Simakade delivered an affidavit.
yes, and he was cited.
Yes, and he was cited.
He was
So he had
cited.
an opportunity, in the words of Wallace J, to,
Consolidate.
yes.
May I just ask your Lordship to make a mental note at this stage, because I'm going to forget, and that is that there is a logical and probable explanation why Prince Simakade took 18 months to pursue his claim to the kingship in this application. But the Royal Sishaba Holdings case, which is likewise an SCA decision, the same party's requirement is not immutable, and he cites Caesar Stone. I'm not going to refer to Janssen van Rensburg versus Myburg. It's there for your Lordship to read. I do want to read to your Lordship the case which we do cite, it is either the DA versus Brummer or Brummer versus the DA. I can't remember which. I have the case. Sorry. Lord, it's in our head. I'll give you the footnote. Let me give you, Lordship, the reference. It is in the head. I saw it this morning. It's 2022 ZASCA 151, Democratic Alliance and Brummer, Johan Vikal Kralen Brummer. Its footnote 38 gives your Lordship the reference for convenience in our heads. Now, what happened here was that Mr. Brummer was expelled from the DA, and he sought damages. And there was a prefatory application before the Western Cape High Court for a temporary interdict. And it went to the SCA on the issue of whether the temporary interdict by Brummer rendered the question of liability of the DA for damage raised judicata, because Traverso DJP had refused the application for a temporary interdict. But under circumstances which are completely different to the situation which confronted His Lordship Mr. Justice Madonda, as I shall demonstrate. Forgive me for just reading a few passages. This case is most instructive. I'm not going to bother about the introduction. What the court says at paragraph 14 is the following. Just trying to see the right joke. It was Querson, AJA. And believe it or not, they quote Spencer Bauer on res judicata. The first component of the inquiry requires a careful examination of what issues of fact or law were decided by the first court. In Boshoff, the following statement by Spencer Bauer in res judicata was held to be correct. And this is what follows is the Spencer Bauer citation. Where the decision set up as a res judicata necessarily involves a judicial determination of some question of law or issue of fact, in the sense that the decision could not have been made legitimately or rationally pronounced by the tribunal without at the same time and in the same breath, so to speak, determining that question or issue in a particular way. Such determination, though not declared on the face of the recorded decision, is deemed to constitute an integral part of it as effectively as if it had been made so in express terms. End of the quotation. And the court continues, careful attention must be paid to what the court was called upon to determine and what must necessarily have been determined in order to come to the result pronounced by the court. The exercise is not a mere mechanical comparison of what the two cases were about and what the court stated as its reasons for the order made. There's a reference to a further SCA case, and then in Brummer's case, the case I'm reading from, they cite Boswell's case. And this is important, para 16. Your Lordship has put this to my learned friend. Whether the findings made by the court or the orders granted are correct is of no relevance. A prior determination of an issue, although wrong, may nevertheless support a plea of res judicata. And then they quote African Farms and Townships, a well-known case. Because of the authority with which, in the public interest, judicial decisions are invested, effect must be given to a final judgment, even if it is erroneous. In regard to res judicata, the inquiry is not whether the judgment is right or wrong, but simply whether there is a judgment.
Yes, African Farms underlies the basis for res judicata. That's the principle of finality. If a competent court had determined an issue finally and there's a sufficient identity of the parties, then the only way to attack that is by way of appeal. And then I asked Mr. Dodson as well whether the arguments that the findings were made during the course of interim interdict proceedings is an absolute answer, because if an interim interdict had been granted, of course that would be then subject to a subsequent court's amendment, and then the res judicata issues don't apply because the finality issue the finality element is not present. But if it's a refusal of an interdict, and I think, Mr. Prakken, didn't you encounter that in Cipla at one stage in the SCA? Then if there's a refusal, that's a finality. Yes, because it's closely linked to the appealability of it.
Constitutional court on one side, with 5 on the other side. But, my Lord, let me explain to your Lordship about temporary interdict. They're strange creatures, and just as I've never understood Lillycrap and Wassenaar, I'll make that confession. I've never understood the SCA judgment, I cannot remember the name, which says that the grant of a temporary interdict is not final.
But the refusal
but the
is.
Refusal is.
I think it's Cronshaw with his coin security.
Exactly. The Lordship's memory is better than
No, I have it in Jutastat.
You know the help we can get. But the Lord said, and this is exactly what Brahma was about. I'm coming to that. But to answer your Lordship shortly, I don't believe that this was a temporary interdict, because if one looks at Madondo AJP's judgment, I'm going to show you. I'm sorry, I'm leaping ahead of myself.
You mean it was to prevent the coronation on the 3rd of December of 2022, and if that order is granted, then that's final in effect because there's no coronation then?
Yes, but there was another prayer which said,
pending.
if the third respondent, whom I think was the Premier, had completed all the paraphernalia required, then the President, whatever number he was interdicted from recognizing King Misuzulu. Can I just show your Lordship where that? Look, I have marked up what I consider to be the best copy of the
Is it paragraph 68C of his judgment where the introduction, it says the applicant seeks an order in the following terms: A, interdicting, restraining from preparing or organizing coronation; B, recognizing; and then C, in the event that the fourth respondent had completed all processes envisaged in section 17, that the third respondent be interdicted and restraining from issue a certificate. That's the portion you're referring to.
That's a final. Let me continue with my little excursus on the law.
You were in your head's reference paragraph 12 and 12.3, I think, dealing with the
I was
contents
actually-
of contents of the determined. No, 12 is the.
I was actually enrolled at Paris 16 of the judgment in Brahma.
Oh yes.
And then I want to continue at para 18. And then the council referred to African wanderers, Sipler agreement. That's the one that gives me insomnia and heartburn. And 18, none of these cases, however, support the proposition. They did not hold that the form of the order is determinative of whether it is final in effect. Sipler agreement involved an instance where an interim order had been granted. And then in African Wanderers, Mother J.A. stated that in order to decide whether an interlocutory order is appealable, of course, whether it's final or not final, in the old days before Section 18, and based on Zwelithini and Holland's J.A.'s judgment, one must therefore examine the issues raised before Howard J. in the interdict proceedings and the manner in which he dealt therewith in order to determine whether he meant to express a final decision thereon, i.e. whether he intended to dispose finally of those issues or any part of them. So the Lord, one doesn't just look at the order, one looks in African Wonders, as I stated, you must examine the issues raised and see how they dealt with, to see whether the judge intended that these, the judge or the arbitrator or whatever award or order is being raised as a defense of raised judicata. You examine the way that the judge deals with it. In the Mkhize matter, I'm still quoting from Brahma, in the Mkhize matter, the question arose in relation to the dismissal of an application rather than the granting of interim relief. The following passages from the judgment illustrate the approach that is required in this matter. And then he quotes, the orders of Boyne J, the Supreme Court of Appeal, and Sishi J, all concerned the Rule Nizai and the Fonsale J order. The pertinent question is therefore whether an order can be considered final when it is concerned with dismissal or discharge of interim or interlocutory orders. Now, we're not dealing with that here. And then in CON, C-O-H-N, the finality of a dismissed matter was considered, and the court stated, in dealing with a position where an action is dismissed, Spencer Bowers says that the answer to the question whether anything can be said to have been decided so as to conclude the parties beyond the actual fact of the dismissal depends upon whether the dismissal itself is seen to have necessarily involved a determination of any particular issue or question of facts or law, in which case there is an adjudication on that question or issue. If otherwise, the dismissal decides nothing, except that in fact the party has been refused the relief which he sought. Now, Lord, that's terribly important in the present case. And I should explain to your Lordship why in a moment when we go to his Lordship Mr. Justice Madondo's judgment. I just want to finish with Brahma by interpolating and telling your Lordship what happened. Traverso DJP dismissed the temporary, but in fact the court in a very polite way criticized her for not giving any reasons. And I was interested to see that the entire argument before Traverso DJP was made part of the appeal record, and the SCA in fact had regard to it. But she gave no reason.
That's referred to in 24.
Well, it's 24 years.
Yes.
Now, your Lordship quite rightly yesterday put the question, that if it were a temporary thing, then questions of balance of convenience obviously a prima facie right comes into the picture. And a dismissal, without specifying which of those, in any event, if it were just that there wasn't a prima facie right, or the prima facie right was open to doubt, but the balance favoured the respondent, well then clearly the res judicata cannot apply to whatever issues were decided there. But that is most certainly not what was decided in this particular case.
You say this decision before Madondo J is in the same nature as indicated in 26 in Bremer.
Yes.
The exchanges Bremer's counsel had in mind the lawfulness of the termination of Bremer's membership, which was squarely before Traverso DJP. You say the dispute regarding the process to identify the Zulu king was squarely before Madondo AJP.
Well, in fact, unfortunately for I think the DA, 26 and 27, in fact, non-suited the party, taking the point of res judicata, because Traverso DJP did not, in fact, decide any of those, or did not illustrate the issues as their findings. In dealing with the amendment, Traverso just went on to state, I'm not inclined to grant the amendment. And then the judgment reports, in the circumstances, the application for the amendment of the notice of motion at this late stage is dismissed, and from that it follows that in view of the concessions made by Mr. Knutzer, that the balance of the application can also not succeed.
So you say that 36 and 37 of the judgment in Bremer distinguishes her findings or nature of her findings from that of Madondo AJP.
Absolutely a paradigm of a distinction. And 37, of course, is placing a legal term on it. In these circumstances, the dismissal of the application amounted to no more than an order of absolution. Now, if you compare that to His Lordship, Mr. Justice Madondo, who the Lord grasped the net, he set out, with respect to the Bremer judge, in great detail, the issues. He dealt with each issue, whether it was right or wrong, but he dealt with each issue. He found on each issue, and the Lord, we've given you all the excerpts from his judgment in our heads, but perhaps I would like to emphasize one, that really is the death knell of any suggestion that Mr. Justice Madondo wasn't making the final order.
Must I have a regard to your heads or to the judgment?
It's in my heads, but it's at 103 of the judgment, 001, 170 I'm reading from.
Yes, I have it.
Do you have para 103 of the judgment?
This is one of the hard copy instances that I have handy.
Yes, yes. Well, he says, the evidence establishes that there is no contender to the throne who professes or is professed to have a better right, entitlement or title to succeed to the throne than Prince Misuzulu. The applicant has not made out any case that the identification of Prince Misizulu as the successor to the throne was not in accordance with Zulu customary law and customs and the provisions of Section 8.1 of the Leadership Act read with Section 17 of the KZN Act. The applicant has accordingly failed to establish any right which is protectable by an entity. It couldn't be clearer. And then in the result, the application is dismissed with cost. Whilst you have Justice Ndonga's judgment. I'm coming to another issue in due course, but I don't want to have to refer back. Yeah. In para 99, look, we have seen the argument of, I think, Mr. Madonsela, which is, I think you're on case lines now, on behalf of, I think on behalf of the King. And one of the issues which was certainly pertinently raised, and in 99 he says, none of the queens who are the wives of the late Isilo is the mother of Prince Simakade. He was born of a spinster, as his mother had never married the late Isilo, and he cannot, therefore, under customary law and traditions, oust the children of the great wife and of any of the other queens. He has therefore no basis for contending for the throne at all in terms of the Zulu customary law and custom. The king is appointed on the basis of the status of his mother, and he cites his own work there. As the appointment of a king or queen is done under Zulu customary law and traditions, the exclusion of Prince Simakade from succeeding to the throne in this case cannot fall foul of the equality. He can only succeed to the throne in the absence of any male issue by the late Isilo in any of his houses. He must be first linked or assigned to a great house with the consent of the great wife, or whichever wife in terms of the Zulu custom and traditions should be bearer of the successor to the throne. The late queen had sons, and such sons, including the king, the present king, could not be ousted from succeeding to the throne by any of the late Isilo's sons from other houses, even if their mothers had been married to the late Isilo during his lifetime. And then in 100, Prince Mbonisi, acting on his own frolic, brought this application before this court on the pretext that he was acting in the interests of the royal family and the interests of peace. Lord, the only issue which I learned friend Mr. Dodson raised was that, well, clearly Mr. Justice Ndonga did not make any findings on the recognition itself, on the review. Not the recognition, sorry, on the review, on this application. Now that of course is true, and Justice Ndonga realized that. He couldn't prevent anyone from seeking a review on any other basis. Those set out in 16, for instance, section 16 of the Act. I can't remember, there are about 5 subsections. But one thing is for certain, with respect, the setting aside of the President's decision requires the prefatory steps, at least, of showing that the nomination, not the nomination, the identification of the King Misuzulu was not in terms of customary law. It would absolutely thwart Ndonga AJP's judgment and the principle of res judicata if you could circumvent the prefatory steps to the review by simply saying, well, the review itself wasn't before. The bases for the review were before, including, as we've seen, the letter from Princess Now,
Well, on the other issue of the Section 8.4 inquiry and dealing now with Princess Tembi's letter, does the principle of res judicata also apply to Madondo AJP's findings in that regard?
There's a second dimension to Judge Monday judgment. One, as I've now argued from my learned friend, was res judicata. But there is another dimension to the judgment, and that is that it's a binding judgment upon the parties. Now, the judgment of a High Court judge who has wide common law and constitutional jurisdiction to decide issues can never be trumped by a decision of an investigative committee. Now, the President is called as a respondent in the Mbonisi application before Judge Madondo in Maritzburg to come and show why he should not be interdicted in perpetuity from recognizing the present servant. Why, my Lord, would he prefer the opinion of an investigative committee when he has a court judgment which says exactly what the issue is and how it should be decided? He is bound by that judgment, even as the President.
What about Mr. Dodson's argument to say, and Mr. Masuku's as well, to say, but it's a mandatory requirement if there is a dispute that he refers it to a committee, and the committee might say, we have very little to do seeing that it's already been decided, but we have spoken to A, B, and C, and here's our report, read it with the judgment. I hear what you say, so there's a binding judgment. What about the argument to say, well, even if there's a binding judgment, it must go through the 8.4 process once the threshold has been met?
A binding judgment is a binding judgment. The act cannot trump the judgment. The President has to obey the judgment.
Yes.
And it's a submission that I'm going to make in respect of your Lordship, with great respect. Your Lordship is far better armed to decide these issues than an investigative committee, including a member of the, I think, the tradition. I can't remember what the composition of the committee is, but we have 6,000 pages, 9,000. We have 12 council, apart from themselves, very eminent, and we've had 3 days of argument. This is a decision with respect which is eminently justiciable by a court of law. It will, in any event, no doubt land up in a court of law, even if the investigative committee comes back with a report. Somebody is bound, given the litigious nature, somebody is bound to seek to review the decision of the investigative committee.
Yes.
Yes, and my learned friend Mr. Barnes points out to me, they could have appealed that judgment. Same considerations apply. And I'm not going to repeat what my learned friend Mr. Barnes, but the President sagely waited, I think 14 days, before taking the decision.
Yes.
And then there's a third dimension to the case, the Madondo case. Not stare decisis because it's a different division. But we say that together with the evidence in these 6,000 pages, The judgment of a judge, an eminent judge in this field of the law, is persuasive. Lord, may I just retrace my steps, because there was some suggestion that Redondo AJP was wrong about the complaint under customary law. Now remember, we've argued that it has to be a complaint relating to customary law and custom. If one reads His Lordship, Mr. Justice Redondo's judgment carefully in context, it is clear that one of the reasons why he believed there wasn't a complaint was because he found that the basis of the complaint had fallen away. On every single basis.
Yes. Mr. Morane, however, said on that point slightly different, to say, but a basis that there is another contender isn't a sufficient basis for 8-4. It is if that contender's nomination or consideration wasn't properly handled or heard in terms of custom. That could be a complaint. But he said that wasn't the complaint.
I fully support that argument, but I'm also saying...
Yes, I hear what you say. Once you've found that there couldn't have been a contender, or couldn't have been the contender in the person of Prince Simakade, then the complaint fell away because there's no foundation left.
I now then revert to the merits of both cases in the event that your Lordship were to find that res judicata does not apply. Of course, if your Lordship finds that res judicata applies, that's simple. I'm not suggesting your Lordship's looking for a simple way out. Not being patronising, I know that your Lordship won't. But
yes, but in this matter, res judicata upholding or not is not a simple issue. It's not as simple as another matter saying, well, it's already been decided, I need not decide it. It's simple. This matter is not one of those.
I'm not suggesting that the res judicata is a simple issue, but it would be the total answer to everything else.
Yes, well, that's why res judicata is offered as a special plea then, in litigation.
Now, my Lord, the submissions which I am about to make are based upon the merits, the underlying merits, in the event, in the melancholy event that your Lordship does not find res judicata. I deal with Prince Mbonisi's thesis first. I call it a thesis because that's all it is. It is not, his argument is not a tenet of customary law by any means. His thesis is, first, and yesterday Mr. Misuzulu said it, there can be a number of heirs.
There can be a number of?
Heirs. And I think inherent in that proposition is the thought that the royal family, and let's leave for a moment who constitutes the royal family, has to make an election and choose one of the heirs. Now, with respect, that's a heresy in terms of customary law. And I'll just give your Lordship the references. By the way, there is absolutely no authority other than Prince Mbonisi, and I don't wish in any way to denigrate his knowledge or his standing, but he doesn't have any support from learned authors, historical works of the like. We have found authorities on the issues which we deal with in paragraph E of our heads of argument, commencing at 03128, subcut the underlying merits. In 12.2 we remind your Lordship, not that you need reminding, of the Alex Court judgment, which shows how the interface between indigenous law and statutory law and the common law is to be determined. And in 53, on page 03130, this is 53 of Alex Court. In applying indigenous law, it is important to bear in mind that unlike common law, indigenous law is not written. It is a system of law that was known to the community, practiced and passed on from generation to generation. Through its history, it has evolved and developed to meet the changing needs of the community, and it will continue to evolve within the context of its values and norms consistently with the Constitution. And then this is how you prove it, Lord. This is a question that I, quite frankly, had not applied my mind to before I was briefed in this case. Because it's certainly not foreign law, which we know is a matter of fact, but it is also not common law, which one can go and look up in foot and brochure. Paragraph 54, without attempting to be exhaustive, we would add that indigenous law may be established by reference to writers on indigenous law and other authorities and sources, and may include the evidence of witnesses if necessary. However, caution must be exercised when dealing with textbooks and old authorities because of the tendency to view indigenous law through the prism of legal conceptions that are foreign to it. It is said in the course of establishing indigenous law, courts may also be confronted with conflicting views on what indigenous law on a subject provides. It is not necessary for the purposes of this judgment to decide how such conflicts are to be resolved. Well, I would suggest what the court in Alex Court wouldn't decide. Your Lordship might consider that the question of onus must certainly come into it, because you can't just leave the matter like the wreck of the Mary Dear floating in the ocean. The Lord, 12.3.2, in customary law in South Africa, T.W. Bennett, the position is stated thus: the legends and traditions of most South African chieftaincies regard the first person to settle the land as the founding father of the nation. Thereafter, according to the principle of patrilineal succession, his office was inherited by his eldest son. If a deceased ruler had contracted a series of polygamous marriages, his heir would be the eldest son of the principal wife, whose rank was usually denoted by the fact that the subjects had contributed towards payment of her lobola. And then Bennett continues, the Lord, in 12.3.3. I really don't want to read all of it. The portion we've emphasized, with the Zulu, for instance, a woman of an aristocratic family takes precedence over other wives. And then we quote Judge Madondo writing extracurrially, and your Lordship will read that.
Yes.
Now, the Lord, there is such a common sense reason why there is a system of law which provides for succession.
But tell me, on this topic then, if it is so simple and almost predetermined, what value or input or weight would the selection of a successor by the late king himself have had then?
Can I say this? Your Lordship uses the word selection. The Act uses the word identify. There's a distinction. The family, the royal family, does not select. The royal family identifies. It is formalistic, we suggest. It's ritualistic. If there is one heir and there is a...
Then it's ritualistic, it's predetermined.
Predetermined. There is a statement in Prince Simakade affidavit, the one at the start, which says Zulu kings are born, not elected. And that sums it up. But I'm going to suggest to your Lordship why there is this body of rules which determines patrilineal succession and upon whom the crown should devolve. And that is a lesson learned from Zulu history itself. If one reads all the history back to King Shaka, and one reads, as I have again, Mr. Morris's book, The Washing of the Spears, one realizes that the battle for succession, for instance, between Pande's sons, Chetswaya, and I can't remember his brother, ended in the bloodiest battle in Zulu history at the place of Bowen. So one can't have a number of heirs squabbling and horror upon horrors taking up arms and getting armies to support them in order to determine who shall be the next ruler. It must be predetermined. That person is born. And the process of identification is simply ritualistic and formalistic.
And then you make reference to the late Queen's letter, and you say the late Queen's letter accords with this.
The Queen's letter is not determinative of the issue.
No, but it accords with it, I say. I didn't say...
Yes. Well, the Queen's letter does more because there is a misleading statement in Prince Simakade's affidavits. He refers to a book as the Queen's book. And he says, and it's
yes.
2A and 2B.
But she didn't write it.
And he says, in 2B, you will see that I'm referred to as the king's son, and it proves that I was my mother's favourite, etc., etc. When you actually look at the English translation, it says completely the opposite. But if we don't have to traverse it, we won't. But what we say is that the letter proves that whatever Prince Simakade says in his affidavit about him being his mother's favourite and that accolades were showered upon him as a child is simply not true. And that's what the Queen's letter impliedly says. It is my son, Prince Misuzulu, who is the heir.
Why does she then in a letter say, but I hope it finds favour with you? Why does she then in a letter says words to the effect, but I hope it finds favour with you? Or words to that effect? I don't have the letter now in front of me.
Well, she says, whilst I'm humbled by the honour, I believe it to be appropriate and befitting of the great Zulu nation to bestow the honour given to me by His Majesty to my son, King Misuzulu. It is a formal letter, after all. In her mind at least, now my lord, the evidence is put out not in order to prove the content.
Oh, you mean if it is the approval must be read in context of paragraph 6 to appointing in her stead. I see.
The evidence is put up as tender. It is with respect in much of the striking out application brought by Prince Simakade. There is a confusion between evidence tendered for the correctness of the version and evidence proving a state of mind, which is part of the res gestae, or, for that matter, proof of the fact that there is a letter or there was a letter.
But the attorney from Kavanagh attorneys, Richard, says we're not tendering it for the truth of the content, we're tendering it for, as you know, said, this is what happened. That was already the position at the postponement application earlier this year. The existence of that letter was, and the dispute regarding the deposition thereto was what led to the postponement.
The word calls for the author. You know, I don't know why my learned friend spent so much time on Prince Simakade's letter of the 11th of March, because I had thought that by not persisting with the issue of substitution, Prince Simakade's status as heir to the throne was not relevant to the issues any further. But he's dealt with it, and I would like to deal with it because I believe that the context which he has sketched is incorrect. First and foremost, I'm not going to read the letter again. Your Lordship can read it, and there's no magic or mystery. But here is the context.
You refer to it in section G of your heads.
Yeah, we do.
And that's your, yes, your interpretation as a renouncement of entitlement.
But I just want to add something to these here. It's a chronology. Much is made in argument, and no doubt in the affidavit, written probably by the same author as the argument, that he was just humbly, he writes in the past tense. He says, had I been nominated, I would have been honoured as a humble person and all that. But let's not forget on the 7th of May, sorry, the 5th of May, I keep getting that. The 5th of May, there is a secret meeting, admittedly of not the whole royal family, but one of the families, identifying Prince Simakade. That was sought to be ratified on the 23rd of May. But now against that background, why on the 11th of May, having been, let's use the word nominated, does he write this letter and give it to Prince Bhekuzulu? Makes sense. And then the explanation is tortuous. He says, well, I gave it to Prince Bhekuzulu. It was misread. Prince Bhekuzulu didn't even read the letter. He gave it to another prince. His name now is used. to read out. How do you misread the letter? I mean, it's obviously in Zulu, and he says to the assembled gathering, this is what Prince Simakade says.
Wasn't it reread at the later meeting as well?
I'm sorry, but
Wasn't it reread at a later meeting as well? Or was it read by the mediation committee?
forgiveness, my Lord. I can either hear or I'm hot, so let me rather be hot.
I refresh my memory through these thousands of pages. Wasn't the letter reread at a later meeting? Didn't the...
It was read on the 14th.
Yes.
14th of May. Well, Prince Bhekuzulu, Common Cause, was asked to read it at the 14th of May. And the minutes portrayed it.
Then in your heads you deal with these allegations in his affidavit to say, had I known what had happened, that neither correct customary nor statutory process had been followed, I would not have sent the letter.
No,
Or he says, at least not in the form that it was.
no, not in the form that it was. Now that's, of course, an admission that the form that the letter took is what we say it took. A renunciation. But he couldn't have been prescient. He wouldn't have known that the 14th of May. He says, what he subsequently discovered, i.e. that neither the correct customary, not sick, the correct statutory process had not been followed, well, he didn't know that on the 11th.
Yes. The next section, H, the decision to recognize you've dealt with stare decisis. Yes.
Yeah. We piggyback on the President, lady and man. Lord, may I just confer with
Yes, certainly.
you on my view? My Lord, I'm not going to deal with anything, certainly not without striking out. Your Lordship knows well what is hearsay, and in any event, the modern view is that hearsay evidence in application certainly is more readily admitted. Your Lordship will accord such weight to whatever we say is hearsay. We ask for condemnation for the late filing. We believe we've given a credible explanation. Your Lordship will have seen we've explained. We've never consulted with Prince Bhekuzulu. He's been in extremis since we have come into this case, and he was our sole source of information at that stage. We struggled, I'm not criticising the other firm of attorneys, but we get 60,000, leave off, thousands of pages, middle of August sometime, without an index. Of course, there are no case lines with no digital recording in the Maritzburg court. We asked for condemnation.
I understand there's even very little case lines there.
Sorry.
I say I understand there's even very little case lines there.
Yes. Yes.
Well, such is the rumor.
Sorry, I missed that. So Lord, we simply ask that your Lordship grant us condemnation. We want to give your Lordship the assurance that this was not in any way disrespectful of your Lordship's directive. We tried our best. And
But even if I were to disregard the unsigned affidavit of the late Prime Minister, there is his signed affidavit which served before Madondo, AJP.
well, the signed affidavit is in the Mbonisi application.
Yes, yes, that's what, yes,
It requires no admission.
yes.
We do ask your Lordship to have regard to the unsigned affidavit under Section 3. Can I give you the leading case here on Section 3? It's a full bench decision here in Pretoria. It doesn't deal with the specific issues raised in Prince Butalezi's unsigned affidavit. It is Hewan, H-E-W-A-N, versus Kuri, K-O-U-R-I-E, N-O and another, old TPD, 1993, Volume 3, SA 233, and it deals at length, judgment of His Lordship Mr. Justice du Plessis, dealing with the application of Section 3. And the Lord, all it does is it says that Section 3 invokes that wonderful thing called judicial discretion.
Yes. Well, it wasn't intended for the truth, it was intended to say this is what the late Prime Minister would have said. Here's his affidavit, we had no hand in it, it was drafted by someone else, and as I recall, the dispute in the postponement application was not that he refused to sign the affidavit because of the contents, because of something completely extraneous to that affidavit and to this litigation.
Exactly correct, Lord. And he says he's not going to disclose it. We had hoped that we would speak to the two of them and resolve that difference, which had nothing to do with this case, nothing to do with his evidence. And in any event, if one compares the unsigned affidavit with the signed affidavit in the Mbonisi case and the affidavits in the TEL, you will see that he's singing from the same.
But that's why I say that even if one were to exclude the unsigned one, one has the other signed one. And how much is the difference between the two?
There's a little more. To
because there's some added chronology which is added.
There's
But the initial explanation is the same.
The initial explanation is the same, but he does go on to deal with this question of
the meeting.
The Queen's book.
Oh, yes.
I don't know. Yes, just
But I'm
on
not. But I'm not sure how much turns on that now that we're not having a remittal. Not having a paragraph 8 and 9 of Prince Simakade's application issue.
Yes, and one doesn't argue issues simply on credibility and costs. May I just give your Lordship the reference to Schrickert, Principles of Evidence. It is section 13. Is it not? It's at page 263 of Schrickert, and it cites Van Sale versus Jonathan Ball Publishers. That is 1999 4 SA 571, the old Witwatersrand Rand Division. Justice Nafsa held that a court in exercising its discretion should consider the difficulty a respondent may encounter in meeting a case on an urgent basis. Other circumstances that might make it necessary to introduce hearsay evidence would include the death of the declarant, etc. Yes, I said that the signed version of Prince Buthelezzi's affidavit was in the Mbonisi application. It's in case 35599/22 in this application, the interlocutory application. It's can I just give your lordship a case line briefly? 030-153. In the Mbonisi application.
Yes.
Lord, as always,
Sorry, we're struggling to find the document, and it's important for us. Could we just be given a moment to check that that was the correct reference?
All right.
Did you hear the reference, Alan?
In
You've got it, thank you.
Okay.
the reference given, I think, was the file note, the filing note. But there it is. It starts at, well, at 030-159. You will see, I, the undersigned, Prince Mangosuthu Buthelezi, do hereby make oath and say. Mr. Dodson?
Thank you.
Thank you.
Lord, I omitted to make just one or two submissions about the 14th of May. Again, on the supposition that your lordship dismisses our defence of raised to decline. The 14th of May, there was an agenda. There is an affidavit by a prince who, the name I cannot remember, who says he telephoned the people himself on the instruction of Prince Buthelezi. They came to the meeting. They must have known about it. There's nothing improbable about him having phoned them to tell them to come to the meeting. It is true it was also the cleansing ceremony.
If you say them, you mean the members of the royal family?
Yeah.
Well, and others who attended?
Others apparently attended, but only identified in reply.
Yes.
The vast majority were members of the royal family. There were, I think, two religious personae. Lord, what is also important is that both Mbonisi, Prince Mbonisi, and Princess Tendi were invited
But
and declined the invitation. That point has been made. Prince Simakade obviously knew about the meeting because he asked for the letter to be read there. So he took an a priori decision not to attend the meeting. It was a unanimous decision. Now, one trusts that when this act, when the new bill is written, persons are asked for comment in order, I hope Parliament gets down to it within the 2 years, may be such issues as Cora and the like that are included in the bill, but be that as it may.
Even if it were to be included, it'll be again in terms of the custom applicable.
Yeah. Well, Prince Buthelezi says that's the custom. Professor Ngobani says that was a properly constituted meeting in terms of the customary law. I do want to say this about and there is another expert whose affidavit was supposed to be filed at the time that, in this application, it was supposed to be filed at the time, but it went missing in the 60 lever arch files. We were completely unaware of that affidavits. We've put them up now, and there is an expert. I'll have to give your lordship the reference tomorrow, I'm afraid. It's in the latter part of the I do want to say this about the expert that Prince Simakade has called.
Is that Simon Jabulani Mapalala? Yes.
Yes, Masala.
Well, the H is at a different space than here. Mapalala.
Malala.
Yeah, it's not HL. It's Maphallal. A. Mapalala.
I failed to the pronunciation at school.
Well, I'm reading from the second application to strike out.
Yes.
But that's the one you're referring to.
What I would suggest is that in a matter such as this, where indigenous law is a matter of law, but it's not a matter of law that all judges or all of us lawyers know and perhaps have studied, a court will be loath to turn a blind eye to any evidence that may be before it in order to determine rather abstruse questions of indigenous law. I'm trying to find the affidavit filed on behalf of Prince Simakade. I want to make this criticism of that affidavit. In the recent judgment, which I shall get to in a moment, the SCA, I believe, has criticized the practice of an important witness with important evidence simply confirming what is said in the mouth of the founding affidavit, for instance. Yes, it's at 059-313. That's
In which matter is this now?
This is in the Simakade papers, and it's 059-313.
Yes.
And can I give your lordship a reference to the Drift Super Sand Proprietary Limited and Bukhali City Local Municipality, and another, it is case number 1185/2016. We shall load it onto case lines. It's paragraph 31. Yeah. And it dealt with the evidence of a certain Mr. Van Dijk. Well, I'm not going to read it all out, but it says if the evidence of the affidavit which is annexed, or if the evidence of the deponent whose affidavit is annexed is of great importance to the case, critical to the case, it is not sufficient to say, to put it in the mouth of another deponent and confirm it. It should be in the affidavit of the person who's giving the evidence. The court says this might be an acceptable way of placing non-contentious or formal evidence before court. But whereas here, the evidence of a particular witness is crucial, the court is entitled to expect the actual witness who can depose to the events in question to do so under oath. And so, as always, to cost. I noted with interest that the two applicants gang up on the king, and I thought it was a little temerarious of Prince Simakade to ask for the costs of him opposing the Mbonisi application, which I say he should ask you to dismiss, that he should ask that we pay the costs of, that is, the king must pay the costs.
Sorry, not correct. In relation to Prince Mbonisi's application, if I'm understanding the submission correctly, we asked the President and the Minister to pay the costs.
Sorry?
In relation to the Prince Mbonisi application, we only asked the President and the Minister to pay the costs.
The Minister.
Does it change much? Mr. Perkin, yes. In a matter such as this, one shouldn't express any prima facie views, except perhaps for purposes of debate, the issue of costs. Can it really be said that persons here acted out of own spite or malice, or were they all concerned regarding what has befallen the Zulu nation regarding the disputes of succession?
The epithets flew fast and furious in the affidavits against the king, but we don't take umbrage with thick-skinned, and I'm not suggesting that anyone acted with malice. Can't prove it on affidavit. So if your lordship is referring to the Biowatch principle, I can't.
Well, I wasn't so convinced it was that much of a constitutional issue, but it will result in the same end in an exercise of a discretion.
Well, of course, the guiding principle will be the outcome of the merit.
Yes, yes.
Really, I can't lecture the lordship on the costs. I mean, the lordship will know what to do in the lordship's discretion, and it will largely depend on the outcome of the decision.
Yes. Thank you.
Thank you.
Mr. Masuku, we're not going to finish today.
Indeed, we are not going to.
And I would be surprised if you could give me a guarantee that we would be able to.
I thought I got a good commendation from you of my ability to stick to time. But in light of the debates that you raised with our colleagues for...
Yes, no, what I'm saying is if we're not going to finish today, we will definitely finish tomorrow.
Absolutely.
But is there then a need to start and interrupt your argument, or can I hear you tomorrow morning and then Mr. Dodson thereafter in reply?
No, there is no need for it. We were quite happy to start tomorrow. We'll be fresher and more focused.
And also you'll have an extra 20 minutes then to prepare on the argument you've now heard.
Exactly. But as I recall, Mr. Smelada will deal with reply. I'll deal with only one aspect.
All right, you can structure it however you want. Court will then adjourn until tomorrow morning.
Because